This is Shane Rolf, host of the Bail in the Midwest podcast. The following episode concerns the increasing influence of politics in America's bail system and features our guest, New Mexico bail agent Gerald Madrid. Halfway through our recording session, Gerald received a surprise visit from Christopher Marlowe, an Albuquerque-based defense attorney with more than 20 years of experience in the industry. He joined in on the conversation, offering his unique insights, which we are pleased to include as part of this podcast.
You're listening to the Bail in the Midwest podcast.
Hello and welcome to the Bail in the Midwest podcast, where we explore a variety of topics related to bail, pretrial release, and the criminal justice system in the Midwest. My name is Shane Rolf, and I'm the Executive Vice President of the Kansas Bail Agents Association, and I've worked in this field for the past 35 years. Today, we'll be talking about the confluence of bail and politics. As we've noted before on this podcast, the Biden administration campaigned on the policy position of eliminating so-called cash bail. And the idea of eliminating cash bail has become a real political football of late as crime has risen. Of course, as the federal court system has already virtually eliminated the use of any sort of secured release, relying instead upon preventative detention in about 3/4 of all cases and releasing the remaining 25% onto what is essentially pretrial probation, the Biden plan to eliminate cash bail could only be done at the state level. And a handful of states, largely blue states for lack of a better term, have been foolish enough to be test cases for this social experiment, with dire consequences for their criminal justice system and their citizens. My guest today hails from one of those states, New Mexico. Gerald Madrid is the president of the New Mexico Bail Bond Association and can talk to us today about the 2016 constitutional amendment in New Mexico, the changes to the court's rules following that amendment, the consequences that the people of New Mexico have been subject to as a result, and finally, the political activities that led up to these changes. Gerald, welcome to the podcast. I generally open up by letting the guests give us their CV and background and experience in bail world. So if you could give us your background a little bit there.
Good morning. Thank you. This is Gerald Madrid. I'm from Albuquerque, New Mexico. I started full-time in bail January of 1984. So I'm in my 39th year now. I was in it a little bit before that while I was in high school and college, but just kind of part-time. But I did go full-time 1/1/1984. I had my own office here in Albuquerque, and I had, before bail reform, I did branch out and have 3 or 4 other offices around the state. But since bail reform, I had to let everybody go, including 10 full-time employees in my Albuquerque office, had to let them go. And I'm down to working alone in my Albuquerque office. I have committed to the professional bail agents of the United States and other colleagues that I would not quit. I'm basically the only full-time active agent in New Mexico. I have a son that works for me, and then I have 2 other agents, sub-agents that work for me. They've been in a couple of years, but again, I'm the only active full-time. I'm definitely the only active bondsman in Albuquerque, a city of about 900,000. I'm the only bondsman here, and it doesn't matter because the judges in Albuquerque will not set bond under any circumstances. It's either a release on recognizance or hold in jail without bond indefinitely. And this is done by the same judges that used to set what we call good bonds all day long. They would set good bonds. But when bail reform hit back in 2016 or so, it completely gutted the bail bond industry in New Mexico, forcing about 250 persons that were involved in bail to all leave and go find other sources of employment. So again, right now I'm still holding on by a thread here in Albuquerque. The only way that I can keep my doors open here is I have 2 other businesses, and that's how I maintain but my business in Albuquerque. Because there is no bail in Albuquerque, my business operates in the negative. And I do work alone, and I consider myself a volunteer at a nonprofit because I really can't even pay myself, and my business is not profitable, so I refer to myself as a volunteer at a nonprofit. But in spite of all that, I'm not quitting. I'm going to hang on. I'm going to continue doing all that I can do to fight. I do such things as letters to the editor, op-eds. I write different articles that most of them get published. Just a couple of weeks ago, I wrote another letter to the editor and I sent it to every single newspaper in the state of New Mexico, and 5 or 6 of them have published it right now. And it's all dealing with bail reform. That's pretty much all I talk about is jail and bail type issues. But again, I'm still here in my 39th year. I'm not quitting, and I'm still glad to be part of this industry, even though we've been completely reduced to nothing. It's been a great business. It's great, and I believe in it wholeheartedly, and that's why I'm here.
Well, just catastrophic New Mexico. And our sympathies, obviously, we'd like to avoid the same thing happening elsewhere in the country. But let's sort of get into maybe talk about the constitutional amendment itself and kind of work our way through some of the details of how this all came to pass. One of the things that I do is I'm vice president of the Kansas Bail Agents Association, and at our continuing education, every now and then I'll be tasked with presenting something. And one of the things that I presented in the past was about the history of bail. And it's sort of ironic because you talk about what is bail. As a bondsman, you're supposed to know what the history is and what you're doing. You're not just there to make money and run people back in jail. It helps if you know the background of the industry you're in. And so when I would present this to them, one of the very first slides in this PowerPoint that I would put on was something called "What is the purpose of bail?" And you talk about how it balances the presumption of innocence with the right of the state to have the accused appear for trial. Now, I've taken a quote, interestingly enough, from the New Mexico Supreme Court in a case that I stumbled across that I really like the language, and so it's in my presentation. But it says, the release of a defendant on a bail bond is an accommodation of competing interests. It gives not lip service, but full fealty to the basic principles of freedom inherent in our system, that an accused is presumed to be innocent until his guilt is established beyond a reasonable doubt, and it reconciles a sound administration of justice with the rights of the accused to be free from harassment and confinement, unhampered in the preparation of his defense, and not subjected to punishment prior to conviction. Now, that was the New Mexico Supreme Court in 1982, and that's a full-throated endorsement of bail. And then in 2016, did this proposed amendment, because I've got the amendment here, and we'll read over it in a second here, but did this amendment, was this generated by the courts and presented to the legislature, or was this generated by the legislature and then the court sort of endorsed it?
So let me give a brief history on this. In 2011, we had a young man named Walter Brown. He was arrested in Albuquerque. Apparently, he had gone to a party and got into a physical confrontation with another person at the party. He ended up pulling the knife and stabbing and killing the other person at the party. Walter Brown was arrested, booked here in Albuquerque. He was indicted. At his arraignment, the district court judge set his bond at $250,000 based on the severity of the crimes. He then sat in jail for the next 2.5 years here in Albuquerque, and the case was never brought to trial. In that whole time between the state and the defense, it was never brought to trial. That right there was the beginning of bail reform. The Chief Justice of the New Mexico Supreme Court, his name is Charles Daniels, took this whole idea that bail in New Mexico or bail anywhere is not fair. County jails around New Mexico have 30 to 40% of their jail inmate population sitting there simply and only because they can't afford to post the bond that the judge set. In other words, saying that this defendant has no other criminal history, has never failed to appear, has ties to the community, and is not a flight risk at all. However, they're still sitting in jail. So based on that premise, Chief Justice Charles Daniels then began a campaign around the state of New Mexico called bail reform to get rid of cash bail. And it was all based on the Walter Brown case. Walter Brown versus the state of New Mexico. What ultimately happened in that Walter Brown case, though, was, again, Walter Brown was eventually released ROR after 2 years and about 4 months of sitting in custody here. The New Mexico Supreme Court changed his conditions of release from $250,000 to an ROR, released him from jail, and the case was dismissed. He was never tried for the murder. It was dismissed. And so based on that whole idea that cash bail is unfair, Justice Daniels ran with that whole idea, was going around the state of New Mexico making presentations, giving speeches, and I think even out of New Mexico was giving speeches to different groups as to how unfair cash bail is. On 2 different occasions, I was able to debate him in public on cash bail versus the bail reform idea that he was bringing. It was, now that I look back on it, it was very intimidating because he was a lawyer. He's the Chief Justice. He's a very savvy politician. And, I was nobody. Yet I was able to kind of stand my ground there and go toe to toe in a public forum on this. And it was very difficult to do, but I had to stand up and do it. I had to do something. I had to say something, and I fought to the best of my ability. But then what happened is the New Mexico Supreme Court, then they just came in and on their own changed the rules of criminal procedure. This had nothing to do with the legislature. They did it on their own. And Chief Justice, again, Daniels, he was the Chief Justice at that time. It was a complete and total conflict of interest for him to be doing this. This was his pet project. He even said several times, he said, this is my legacy. This right here is what my whole law career is based on, is me bail reform and me getting rid of cash bail. So he took a personal interest on it, went around the state. And again, nobody stood in his way. Everybody got out of his way. Every legislator in the state, every politician, every lawyer, nobody would stand up to him. I guess he was that intimidating. And so it was basically me against him. And again, I don't have the clout that he had. I don't have the backing of the state, the finances of the state. Yeah, and he was flying around the country and around the state, of course, on the taxpayers' dime, presenting this idea that cash bail has to be eliminated because it's unfair. It's holding the poor people in jail, and the bondsmen are to blame. And so what happened again is that the New Mexico Supreme Court then changed the rules of criminal procedure and basically took secured bail or cash bail out of the equation.
On the Brown, go back to the Walter Brown case. If I recall that case, because I followed that a little bit myself at the time, the trial court judge basically didn't make a determination that Brown was a flight risk, despite the fact that he was charged with murder. And it's sort of inherent in a murder charge that you're a potential flight risk because of the charge and the potential sentence that you're facing anyway. And so when the judge did not make a finding, anything other than I set the bond at this amount because of the nature of the charge, then Justice Daniels ran with that particular argument and said, well, there was no flight risk issues, and just completely glossed over the fact that it was a murder charge and there are flight risks inherent when you're looking at a 25 to life or whatever your potential sentence is for a first-degree murder charge. Would that be an accurate statement?
That is correct. And before bail reform, the first thing that would be considered by a judge at the first appearance or the arraignment was the nature of the charges, the seriousness and nature of the charges. With bail reform, it was turned upside down, and now the nature of the charges are no longer considered. They're not even on the sheet that a judge uses anymore. It's not even considered. So it doesn't matter what the nature of the charges are. But because back then it was a murder charge, the district court judge, his name was Judge Ken Martinez, said no, because the nature and the seriousness of these charges, I'm going to set your bond at $250,000 cash or surety. And during that time, though, the public defender's office did file a couple of different motions to review conditions of release or to get a reduction in bond, and each time the judge denied it. But again, for some odd reason, in 2 years and 4 months, the case was never brought to trial. And yet, who gets blamed for that? The bondsman got blamed. When we have no control over cases going to trial, but this is the argument that Justice Daniel made as he went around the state and the country, saying this is proof that the system is unfair to the indigent and the poor people because they're in jail simply and only because they can't pay the bondsman. And therefore, right, if we eliminate the bondsman, the problem is solved. And that's how he sold the idea. He was very, very convincing. Anyways, after the Supreme Court changed the rules of criminal procedure and said that the charges can no longer be considered, and that the first option of release is release on recognizance, and that's the preferred method, it essentially did away with bail. But the next thing that Justice Daniels did then, he went on a campaign to amend the New Mexico Constitution. And so therefore, it kind of went hand in glove, and he was able to bypass the legislature. It got put onto the ballot in 2016. That was an election year, and the constitutional amendment was on there, and over 80% of the people that voted for it voted in favor of amending our state constitution. And again, the way it was worded was very confusing. And of course, that continues to this day to get rubbed in our face that over 80% of the people voted for it. but not a person that I've met said, boy, am I glad that I did that. That sure did straighten things out. Anyone that I asked about that said, I was very confused. I was misled. And I really thought that the way he presented it was going to take care of the crime problem. And of course, it was very misleading. Justice Daniels back then in presentation would say, listen, guys, this is what I'm doing. I'm not trying to get rid of the bondsman. What I want to do is I want to release the low-level offenders, the first-time shoplifters, the DWI guys, just give them a quick ROR. Then the worst of the worst, we're going to hold in jail without bond. And then everybody in the middle, you bondsmen are going to, it's going to be yours. You're not going to lose anything. That's how he presented it. So again, it was very convincing. It was all a front. And that's not what his intention was at all. As soon as the voters voted to amend the Constitution by an overwhelming majority, boom, that was the end of it for us. I mean, it changed like turning off the light switch. He had exactly what he wanted. The next thing that happened was on first day of July, 2017, all the jailhouse bail schedules came down. That was another part of the rules of criminal procedure, is that jailhouse bond schedules were now considered illegal, or inappropriate. They were not allowed. So all the jailhouse bond schedules came down on July 1st. That was the beginning of the end for us. There was no more bond.
Okay. Well, let's look at the actual constitutional amendment, because there were a couple of versions of that were floated. Because I read over this as I was prepping for our conversation here. The Article 2, Section 13 starts off like, and it's identical basically to the Kansas Constitution. I think at least 32 other states have the same language. It says all persons before conviction shall be bailable by sufficient surety, except for capital offenses when the proof is evident or the presumption is great, and in a situation in which bail is specifically prohibited by this section. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Now, that's the same language that's in the majority of state constitutions on this. It's sort of taken from the Eighth Amendment of the Constitution, but it actually includes that sufficient sureties language to prevent the government from just throwing you in jail and asking for an exorbitant amount of money without the ability for you to post bond. And it looks like the first iteration of this amendment that was put out added a couple of paragraphs in there to essentially create a preventative detention mechanism that would expand beyond just capital cases. And then there was a third paragraph that I assume came from Justice Daniels or someone else that says, no person eligible for pretrial release pursuant to this section shall be detained solely because of financial inability to post a money or property bond. So essentially, that's the same argument that comes out in the O'Donnell case in Texas that, well, if you don't have the money to post bond, then we can't hold you. We have to base our bond solely upon your ability to pay that. Now, if I recall, my reading on this was, did this language come down? Was this this first iteration, not the one that actually went before the voters, but this first one, did this come from the courts, or did someone else create this, or was this like a committee sort of set up that came up with this language? You know what the source of this particular language was?
Justice Daniels was basically him, and there was another local attorney that were drafting this language, and they're both lawyers, and the rest of us were laypersons. So it was, it's an unfair fight for us because we're not attorneys.
Okay, so it was the Chief Justice of the Supreme Court who drafted a proposed constitutional amendment.
That's correct. Okay. One other side note that I wanted to mention to you is that while all this was going on, I even filed a judicial standards complaint against Justice Daniels, saying this is a absolute complete conflict of interest for him to be doing this. My complaint was very quickly dismissed, that it was baseless. I still have the letter here. After a couple of weeks, I got a letter back from the Judicial Standards Commission. Yes, we received your letter, but it's baseless, and so we're closing out your complaint. And that's what I expect.
Right. It's a little tough to file a complaint against the boss and expect the underlings to actually enforce that.
Oh, yeah, because, they all report to him. They report
exactly.
to the Supreme Court. And he was the Chief Justice. And, there was lawyers that I talked to back then, and they said it's an absolute conflict. I mean, this is not even close. But again, as I said earlier, Justice Daniels got away with everything he wanted. Who was going to tell him no when he walked into a local court, whether magistrate district or whatever? They had the red carpet out for him anywhere he wanted. No matter what he said, it was delivered to him. And I don't know how the guy got so much clout and power, but he did. And he got everything he wanted. I really think, because, you know, I spent a lot of time thinking about this and writing it. He really created a problem that didn't exist, and he already had the answer for the problem that he created, which was that people are sitting in jail solely and only because they can't afford to pay the bondsman. Well, the solution to the problem is get rid of the bondsman. Now the problem's gone away. And so, and I believe, and the other thing that I firmly believe is that private defense lawyers were quietly complaining to him, because I've heard this before. We're complaining to Justice Daniels that, you know, quote, these bondsmen are getting retained before we do. You know, these guys are making money hand over fist. Let's get rid of the bondsman. And now all these clients will come and retain us as private lawyers. Well, it didn't work either, because the way bail reform is situated, again, it's the assumption that everybody's indigent. So if they're too poor to afford a bond, well, then they automatically qualify for the public defender because they're indigent. So therefore, all these private clients, all these clients that the private lawyers thought they were going to get are now with the public defender, because everybody is determined to be indigent with no proof of anything. Of course, they walk in and, you know, at the first appearance, the public defender tells the judge, well, judge, my client is indigent. He can't post any bond. Oh, great. Well, you qualify for the public defender now. Let's go ahead and get you an ROR because you're indigent. I mean, right. There's, again, no proof of anything. It's just the public defender saying that and the judge, you know, going along with it. So it backfired on the public, on the private lawyers as well. The public defenders here now are overwhelmed.
Well, we've heard that argument before. I mean, judges, you know, sit there and well, you know, if you had $500 for this bondsman, you know, how can you not afford your attorney? Well, my attorney wanted $5,000 as a retainer. There's a vast difference between what it might cost to post just your average bond and what it's going to cost to retain an attorney to spend, you know, 100 hours representing you on your charge at attorneys, you know, hourly rates. So, I mean, it is sort of I'm not quite sure what the old euphemism is, but you're basically seeing someone else's, counting someone else's money. Now, the constitutional limit, though, that third paragraph that I pointed out, that's not actually what ended up before the voters. It looks like that third paragraph was changed, and there's some more language in here that looks like perhaps the Bail Bond Association or some of the legislators actually came in and made some modifications. Let me read this third paragraph that actually came through. It says, a person who is not detainable on the grounds of dangerousness nor a flight risk in the absence of bond and is otherwise eligible for bail shall not be detained solely because of financial ability to post a money or property bond. A defendant who is neither a danger nor a flight risk, who has a financial inability to post a money or property bond, may file a motion with the court requesting relief from the requirement to post bond. The court shall rule on the motion in an expedited manner. That sounds like the sort of thing that a bail bond association, and I don't remember the exact details of how that, but might try and get in there to sort of mitigate the damages that just a blanket, if you can't afford bond, we have to let you go, constitutional amendment do. This looks like it created some hurdles and some breakers in there to where not only does the defendant have to show that they're not a flight risk and that they're not dangerous, and that they also have to demonstrate that they have the financial inability to post bond, and they have to file a motion with the court in order to be relieved from the condition of posting bond. Do you recall whether the Bail Bond Association or the legislators that were involved in crafting those changes to the original proposal, if that was their thought process?
That was part of the negotiations between our association, and we had an attorney back then and a lobbyist, and Justice Daniels and the attorney that his name was Artie Pepin. Artie Pepin is an attorney here in New Mexico, and he's in charge of the administrative office of the courts. Anyways, that was part of the back and forth that we were doing, and Justice Daniels used that to kind of appease us, saying, listen, there's still going to be bonds, guys. You can see it right here. It's in the language. And so that's in the language, and that was negotiated out. But it's really meaningless because there's judges here won't set a bond, so there's no motion to file. The only time that these guys will file a motion, the defendants, is because the judge is holding them in jail no bond. So their public defender will come in after the client sitting in jail a couple of weeks or months, file a motion, review conditions of release, not asking for a bond, asking for an ROR. So again, it sounds like the judges are setting bonds on the front end and, sending the guy back to jail. And after 2 or 3 days, he can't post it, but they'll come back over for a second bite of the apple. Doesn't happen that way because the judges don't set bond. It's either an ROR or it's a hold.
Well,
and bond is never asked for here.
In the judge's defense, just the regular circuit judge or district judge, I'm not sure what they call them in New Mexico. They're district court judges here and circuit court judges in Missouri, but they're bound by what their Supreme Court rules are. And it looks like the year after this amendment was passed, Judge Daniels, created a blue ribbon commission or something, basically something to rubber stamp his view, and they changed the rules. If I look at the Supreme Court Rule 401B, basically it says pending trial, any defendant eligible for pretrial release under Article 13, basically the Constitution recently passed constitutional amendment, shall be ordered released pending trial on the defendant's personal recognizance or upon an execution of an unsecured appearance bond in the amount set by the court. So basically that just completely reversed or is the exact opposite of what the constitutional amendment said it was going to do.
Again, yes, that's exactly what happened. What he set up was and I was on the committee, he appointed me, the Supreme Court Ad Hoc Committee is what he called it.
Right.
This went on for 2 or 3 years. I was the only bondsman on the committee, and it was 20 or 25 other members on the committee, and every one of them was an attorney and or employed by the state of New Mexico. I believe I was the only non-attorney on there, and everything that he wanted. So what he did is Justice Daniel then appointed one of his law school buddies to chair the committee. His name was Leo Romero, and Professor Leo Romero was retired from law school here in Albuquerque. He chaired the committee, but he got his marching orders from Charlie Daniels. Daniels, we would meet about once a month. Daniels would give him the outline of what he wanted discussed at the meetings. So Professor Romero, of course, made sure that that Justice Daniels got everything he wanted. He controlled everything. It was very, very frustrating for me because I would go and we would usually be there about 4 hours, like from 1 to 5. And I would walk out of there with a migraine headache because it didn't matter what I said. It was completely ignored. We all, raised our hand to speak for or against whatever it was. And, repeatedly I would say, this is not going to work what this group is proposing. All this free and unsecured releases and all this stuff, it's not going to work. And people wouldn't even respond to anything I said. They would just say, okay, thank you, and move on to the next one. When the next person would speak, it was usually a public defender or something, they were tripping over themselves to go patting him on the back of how knowledgeable he was and just how much sense he made. With me, I guess I just felt like I had my victim hat on then. But it was a 25 against 1. And of course, nobody ever voted with me because the rest of them were judges, public defenders, assistant DAs. Everybody again was a lawyer and or state employee, and so nothing that I asked to have inserted into the rules of criminal procedure, anything was included. It was everything that they wanted, and there was no stopping this. And we probably met for about 3 years, and then of course at the end we all got certificates signed by Justice Daniels. Thanks for your service to the ad hoc committee and all that. And then Justice Daniels just used that to just further tighten up the rules to get rid of the bondsman. And because he already had he had bail reform already here. He had the rules changed. He had the Constitution amended. Now he just followed it up very nicely with the ad hoc committee, which just kind of backed up everything that he said and wanted. There was no stopping this train. It was a locomotive going down the tracks. Me standing on the tracks trying to stop it, and they just literally, figuratively, just mowed right over me because it was just me. I had no help, and so it was very, very frustrating and difficult. But that's what it was—the Supreme Court Ad Hoc Committee.
And I've been involved with those committees before. Kansas recently had one as well, and they didn't even put any bondsmen on. We were able to come and talk and present, and we were there for every setting of it, and they did allow us to talk. But yeah, putting you on there is just simply saying, oh yeah, sure, we covered our bases by having an opponent, to what we're trying to do on here, but they didn't actually give you any
No.
voice to that.
And Justice Daniels used to brag about that. He'd just say how diverse the committee is. We even have a bondsman on the committee.
Right.
And I heard him say that numerous times. And I guess he wanted a pat on the back because I was the token, was what I was. I was the token bondsman just to show that it was diverse and everyone was included. But, it was all predetermined. Professor Romero had his marching orders. He knew exactly what Justice Daniel wanted, and he made sure that he got what he wanted. And there was no, there was no turning anything around. There was no persuading anyone. This is not going to work. And it didn't. This is one of the times when I have to tell them, I told you so, and it didn't work. But
that's a tough one for politicians to swallow.
Yeah, I don't know if you know this, Shane, but our bail association even sued the New Mexico Supreme Court in federal court. Did you know about that?
I believe Candace. I'm not sure if we contributed to that, but I do recall the lawsuit.
Yeah, we filed a federal lawsuit, and of course, lost at every stage of that here. We lost in trial here in Albuquerque at U.S. District Court, and then we appealed it to, I think, the 10th Circuit, which is in Denver. Right. And we lost there as well, too. And of course, Justice Daniels would often remind everybody that we lost at every level, that he's a force to be reckoned with, and it's going to be his way. And it was. He got everything he wanted, and then he died a few years ago. Right. But the damage is done, and nothing has changed.
Yeah, I know the 10th Circuit Court of Appeals was particularly concerning to us here in Kansas because we are a 10th Circuit state. So, I mean, the things that impact New Mexico can impact us as well because we're part of the same federal circuit. I mean, that Pacific Second Reporter Group, as it were. Well, let's talk about some of the failures that have occurred since then, the I told you so part of it here. When I was reading over the rose-colored glasses version of things that the Supreme Court put out, they talk about public safety and go, the New Mexico Constitution now allows district judges to deny pretrial release to dangerous defendants, requiring that pretrial release and detention decisions be based upon evidence of individual risk or danger or flight, not how much an arrestee can pay to get out of bail. For the first time in New Mexico history, district judges may now better protect community safety by denying pretrial release to dangerous defendants, no matter how much they can pay for bond. So you're on the ground there. Is the public better protected like the court says they are?
Crime, of course, is the number one problem facing New Mexico. Okay. And so anyways, my attorney friend just came in and he's well-versed on bail.
Hi, Shane. How are you?
Just fine. How you doing, sir? It's
Oh, very good. I just got out of district court. What's going on?
This is the Bail in the Midwest podcast. We're talking to Gerald today about bail reform and the politics and the New Mexico Constitutional Amendment and what are the results of that have been to the state of New Mexico. Right now, we were talking about potential or the increases in crime, whether or not this actually improved public safety like the court said it would.
Oh, that's you talk about a hot button topic right there. I got to tell you, I've been practicing 23 years, and it's, I'm grateful. It's a privilege to be practicing law in this town or anywhere. But I can tell you, as a former prosecutor now doing defense work, it's been devastating. The public does not have confidence in the criminal justice system. As you are aware, they just call it catch and release, and we're not fishing for trout. I mean, you're talking about people that, for better or for worse, are quite dangerous, being released on felony charges, with access to weapons, with access to victims and witnesses who could testify against them when somebody should be responsible for them, like a surety. And most importantly, in my view, my humble view, and I've said this many times to Gerald Madrid, who I happen to know personally and professionally, as one of the hardest working individuals I've ever come across, is that it chips away at our Constitution. I'm an American first, putting aside all partisan politics. I believe, like General Patton had once said, that other than the Bible, the Constitution is the second most important document, according to him. And I believe you do something, whether it's a social experiment or a specious argument that people can't afford to post, and you come up with all sorts of ostensible reasons, all of us suffer. And you don't even have to be in the criminal justice system or a judge or a lawyer or a surety to suffer. It has a trickle effect. It erodes confidence not only in the judges and people that make these laws, but in government as a whole. As Ronald Reagan once famously said, government is not the solution. They're usually the problem. And this certainly doesn't help. Of course, I could go on and on. I don't want to. I want to give you an opportunity if you have any other questions. I just pulled in from Valencia. It's about a 45-minute drive, so I'm fresh off the car right now.
You make excellent points on that. This is one of the arguments that I've made, and since you're saying the things that I agree with, I certainly think it's wise. That breaking down even something as simple as pretrial release and keeping accountability in your pretrial release, if you take that away, it's pulling away at the foundations of the criminal justice system. Those pillars that society rests on are accountability and law and rule of law and expectations. And if you start breaking those down, society itself crumbles. Now, it might be a little hubris of me, or to sit there and go, well, what I do is helping preserve society, but some little portion of that keeps those bricks in place to where those things don't come tumbling down.
I would concur with you 100%, and I don't believe that's it. I don't think you're overstating anything. Doing criminal defense, you're in and out of the courtroom with such a high level of frequency, and you deal with so many actors in the system, and regardless whether or not I have a high level of respect for Gerald and what he does, but even if I didn't know him, I would still be against bail reform because, again, it just erodes the principles, our liberties, our rights, and the foundations of this country and the Constitution. And it's not a joke. It's almost as though you're removing a link in a chain, and then that chain cannot spin as efficiently, and you're not going to get the power to the engine or the bicycle or whatever it is. The surety is an integral part of the criminal justice system, much like any lawyer or judge or probation officer or detective or police officer. And I think you're exactly right. Once you chip away at those rights, everybody does suffer, and it's not an overstatement. I have neighbors of mine. They're doctors, pharmacists. They don't have anything to do with law. And they ask me every day, hey, what's going on with this catch and release? It's just incomprehensible. It's incomprehensible in this day and age. You look at the recent horrible gun violence and tragedies, incomprehensible to have this in our system.
I had an attorney years ago talk to me about, how the law and changes in the law were like a pendulum, that they'd swing one way and swing the other, and you tried to try and get it in the middle. But what I'm seeing in bail reform in New Mexico and other places is you're seeing that pendulum swing a long way to the leniency side, and it's going to come roaring back to the harsh side. When you just have, like in the federal system, where now you have 75% of people being held on a preventive detention basis for the duration of their case, you're going to see that come back. If you start taking away the balance that surety bail provides, you're going to see a much harsher response down the road from this leniency that we're seeing now, because the society needs to have law and order. And if they can't get it, there's going to be a harsh response to get that back into place.
And I think that's correct. And the irony is the very proponents of bail reform that claim to be protectors of freedom and due process, you're actually chipping away at the due process rights of the accused. Not everyone who's accused of a crime is guilty. I mean, I am not a public defender. I'm a private attorney. So therefore, a lot of the clients I come into contact with, some are doctors, some are other professionals. They may have had a bad fight with their wife. There may have been some liquor involved. It may be a one-time thing. But if they're held without bond, their career is over.
Right.
If Mr. Madrid or one of his colleagues is not afforded an opportunity to post bond, they immediately start getting depressed. Some become suicidal in jail, and they're more likely to plea out of desperation rather than giving their attorney, him or her, a meaningful opportunity to conduct discovery. In New Mexico, we're one of the few states where, under statute, you can request pretrial interviews with state's witnesses. And that's a wonderful thing to fully examine and investigate a case. But you have bail reform, and all of a sudden those rights and privileges, the defendant panics, they're scared, and they don't want to stay in jail. And you're exactly right. And you don't have to be a lawyer to see what's happening in society. Just look at that horrible example of that individual. I believe it was in Wisconsin. He was released, catch and release, and he takes a car and he mows down all these kids or people in a parade.
Right.
Horrible, devastating. And you can't hit the reset button.
Well, and a lot of the arguments that you're making are arguments that are made against bail. Though people are forced into pleas because they can't afford to postpone, but that is only going to be magnified by a factor of 10 if you have people that are there on preventive detention versus even having the option of bail.
Well, and the reality is, sir, is that and I would proffer this to your audience, and I can tell you empathetically, people can afford bail bonds. Certain administrations, I believe it started under Obama, and Eric Holder said it was a violation of their, equal protection, which is just nonsense. Because if someone's poor, that can't mean they can't be convicted of a crime. But when push comes to shove, people find a way to post bond with the bailsman. They have money to travel. They have money for cars. They have money to go on vacation. They always find a way. And of course, Gerald is a better person to talk to about that. But I'm in court all the time and I see it every day. So that's not really a good argument. Another thing that I think is very important, and I think you and your audience understand this, is that there has to be a huge deterrent to committing crime. And posting bond has always been a big deterrent. I always equate Gerald Madrid and the sureties to the Marines. They're always the first to hit the beach. They're always the first to have contact with these guys. And in a lot of ways, they develop close personal relationships, and they're calling these people on a regular basis. Ironically, they're of huge help to people in the public defender's office that have 200 and 300 cases, because they remind them of their court dates. They let them know they're not attorneys, but if they have any questions on court dates or what the court date entails, they can look it up for them. And they're extremely helpful, and they sleep with their phone 24 hours a day. They earn every single nickel of their pay and then some. But I could go on, and I don't want to interrupt your program, and I thank you for having me step in here.
No, I'll let you go save somebody from the clutches of the criminal justice system, and we'll talk to Gerald about this a little bit more.
All right. Thank you very much, sir. You have a wonderful day and a great week. You
too. Thank you very much. Okay, well, let's talk about some specific cases that I've seen in the news. The one that really jumped to my mind, that really, made international news. There's been a couple of them made international news. The first one, though, is the terrorist compound case. If you'll recall, that made big news, and that I forget the exact details of it, but there were people that they thought were training for terrorist attacks in the United States. They found a dead body, and a couple of the people were not even U.S. citizens, and the state of New Mexico could not find it in the current language to preventively detain those people, and actually ended up releasing them. And I think that that was one of the very first shocks to the system that the general public saw as far as what they were getting with this new reform position. Was, if we can't even hold people that are running a terrorist training camp, how are we holding? Who are we preventing from getting out of jail? What did we get in this constitutional amendment? Do you recall? I recall the details of this being that at least you were on ground, so you know better than I do. But I think one of the reasons that one of the only people that ended up staying in custody was because he had federal charges at the same time, and the feds took him after that, and another one had an immigration hold, and they took him on that. Once New Mexico releasing, how are you not considered a flight risk if you have an immigration hold?
That case happened up in northern New Mexico in a town called Taos, New Mexico. And I clearly remember it. It was some people from another country, somewhere, I think like in Ethiopia or somewhere in Africa. And they had set up this compound there. It was a military type compound. They had small children there as well, too. And somehow local law enforcement got wind of it and raided them, raided the compound. They found a dead child there that had been buried for a couple of years. And anyways, they all got arrested. And I remember at the time that the local judge there was releasing everybody, saying, I can't hold them. That particular judge, I think, had to eventually resign, was getting death threats and all kinds of threats of violence against her. And she just kept saying, well, this is what the law says now. I didn't make it. I'm just following the law. And I think she eventually retired or went into hiding or something. I don't remember what happened, but I know exactly which case you're talking about.
Well, there was a news article that I saw just came out recently that, anywhere from 20 to 30% of the people that were put on ankle monitors as part of this program either were out of compliance or weren't even showing up to have the ankle monitors affixed. They just get out and go, I'm out of here, man. I'm not going to get that ankle bracelet. Are we getting, I know that there was a news story about, 1 in 5, I think, weren't showing up for that, or not showing up, but they were letting their equipment die, or they were cutting the bracelets off. Has the court done anything to address that? Are there new charges for those activities, or?
Pretrial services here is involved in every level of every stage of the process here. For example, when somebody gets booked, they've walked into the back of the jail, the first one they come in contact with is a pretrial officer to do an interview. Pretrial services is at the first appearance the next day, giving the judge the background report. Then they're at the arraignment. Then they're at the sentencing. I mean, they're at everything. And they're so intertwined in our system here that nothing works without pretrial. My point is now pretrial is in charge of putting on the ankle monitors. And these defendants, the judge will say, well, I'm going to release you ROR, but I want you on an ankle monitor. Well, guess who puts them on? Pretrial. So the guys get out of jail and they're supposed to report to pretrial and they don't. There's no fishing line there to reel them in. It's, release on a promise to appear, but you better go to pretrial. And again, there's no way to compel them to do that. The problem for us, though, is that we can't get any of their stats. They're controlling all their own stats.
That was going to be my next question. Are they actually releasing their failures to appear, or their failures to comply, or are they, they not at all? No release at all. They're not even redefining it like some other places have done.
We can put in an IPA request, but then they'll come back and say, it's too tedious and too time consuming. We're going to deny your request. They'll come up with some reason. But it's very difficult to get anything like that from the state of New Mexico. And like everything else, it takes time and money. You have to have somebody that knows how to go get that information, what do you do with the information when you get it? How do you read it? How do you figure out what it is that's really happening? And it takes money for all that. And, when there's no money coming in because I'm not posting any bonds, well, then guess what? I can't hire anybody to go do that.
Right.
So it's just a downward spiral is what it is.
Well,
but that's really, I believe, that was Justice Daniels' the whole intent was to do everything in his power to get rid of the bondsman. And in a case, it was packaged up real nicely as we're going to help poor people so they're not stuck in jail. That's how he packaged it. But really, the whole purpose was to get rid of the bondsman at any cost. And it worked. I have to tell you, it worked masterfully for him. He got rid of him.
So in hindsight, and I know everything is hindsight when we look at these things, but is there anything that you think that the Bail Association could have done differently politically at the time that the constitutional amendment was being considered? Perhaps remove the third paragraph altogether, or any alterations to that third paragraph that would have taken away the financial aspect of it while still leaving in the ability of the courts to make the anti-crime argument of preventive detention, because that was the argument that was made. And then they coupled that with let people that are out there poor, let's let them get out. Because I think the public was probably more concerned about the keeping the dangerous people in, less so than they were concerned about, letting the poor people out. So is there anything that you can think of that you might have been able to do different, or did you have the support at the legislature to make any sort of change to that paragraph 3 in the amendment, other than the changes that you made to sort of try and mitigate that?
Well, it didn't go to the legislature. The Constitution was amended by the voters. And Justice Daniels, the Supreme Court changed the rules of criminal procedure. And so the legislature didn't weigh in on it. And in hindsight, what we have done differently, what I think that we should have done differently, it was so difficult at the time that it's hard now to think back, what would we have done differently? We thought that we had a fighting chance to get this done because we were operating from common sense and from facts and what really happens versus the emotions of it, and that it's not fair and we have to level the that the court needs to level the playing field. And it was resources. We had a very small association, maybe 10 people, I guess, and we're contributing, very little amount of money. And, and again, it's hard to keep an attorney fighting on our behalf or keep a lobbyist working, when there's very little money coming in. It was just an overwhelming battle back then. And we didn't have really the guidance on how to fight this. We did have a lawyer, but it seemed like every argument he made was shot down. And, and since then, including the legislative session this year, our legislature has taken up what they call tough on crime bills, and every one have been killed.
When I was a lot younger and I was first becoming involved in the politics surrounding bail, I was at the Kansas State Capitol and I was arguing against a proposed bill that would have allowed a judge to nullify a bond surrender and basically reinstate a bond over the objection of the bonding company, and also would allow the trial judge to order a refund of the premium paid for the bond. So we were up there arguing against that at the time, and I was pretty young at the time and sort of getting into this. There was a person from OJA, which is the Office of Judicial Administration, which is the Kansas Court Administrator's office there. And I guess he took pity on me or something and told me that we, the bondsmen that were arguing against that, we really needed to start an association and that we would have a stronger voice in the Capitol and be able to shape the law better if we had an association that represented lots of people. And of course, I was younger at the time, and I told him I didn't want to simply come to the legislature and ask for things that would just benefit me. And he kind of gave me sort of a benign smile, like I was the biggest idiot he'd ever met. And he told me, and I remember this part of his response to this day because it sticks with me. He says, somebody's ox is always getting gored up here, meaning up here at the Capitol. And the implication of that was that I needed to make sure it wasn't my ox getting gored. So I'll throw this back to you. For states that are under attack from the progressive left, what advice do you have for these bondsmen that are facing this? We haven't done any constitutional amendments in a while, but Alabama, I think, is looking at one. Having been obviously the victim of this sort of activity from the progressive left side of the aisle, how do you recommend that the rest of us fight this?
Well, we have to make ourselves relevant in the equation, how important that we are as far as not just getting people out of jail, but then again, ensuring court appearance and then going to get them when they don't appear. Operating at no expense to the taxpayers and all the things that you already understand. And one of the biggest criticisms that I get constantly is that, well, you're making money, as if everybody else in the process is volunteering. From the judge on down is on volunteer basis. From the judge to the street cop is all just volunteer position. But they probably once a day, somebody on social media will throw a cheap shot at it and say, well, you're making money at it, so therefore you don't have a right to say anything. That you're also, this is all for your own gain, that kind of stuff. And it's hard to kind of shake that, to get people away from that, well, you're making money idea. And they're going to continue to use it against us and the profession. And I don't know how to really get past that. But it is a problem. And as far as advice for anybody else in another state that might be facing this, is that they have to get organized and get in to see the legislators. There's so many people, as you know, to this day, they say, I have no idea what you guys really do. What do you do? And, they'll ask me that. I don't know what you do. And so we need to educate them. And what I do here in my state, again, anything that's free, I do it. The social media posts, letters to the editor, all those kind of things that are free, I do it. And I do it to the best of my ability, and I keep it up to the best that I can, working alone, and stay focused and stay determined that they're not going to give up. And that's the advice that I give, and that's the standard I hold myself to. I'm not giving up. And yeah, it's tougher than heck going home every day saying, you know what, another day I didn't make any money today. but I'll be back tomorrow, and I'm not giving up. And and it's and again, the way I can survive because I have 2 other businesses, but I still have bills here. I have to pay my rent where I'm at, and utilities and insurance and all that. This is not free. And so, but again, I take the position that I'm not quitting, and I believe in bail. I believe in what we do, and I believe in what the Constitution says is bail by sufficient surety, and there's nothing sufficient about a release on a promise to appear over and over again to someone who clearly isn't going to appear.
Thank you very much for taking the time to talk to us today. I know you got to balance a lot of different things. Even if you're not writing bail, you got those other businesses to handle and phone calls to answer and people to service. So I really do thank you for taking the time to talk to us today, Gerald.
It was my pleasure.
Thank you for joining us today on the Bail in the Midwest podcast.